There are those who hail the Israeli Supreme Court as a pillar of morality and justice. Others consider the court to be too powerful. How does the rabbi view this matter?
In modern Western political thought, there is the concept of the separation of powers, the separation between various branches of government. In other words, we have the executive, and after the executive we have the legislative branch, and we also have the judicial branch. These are usually considered to be the three branches of government. Now the question arises, of course, what should the authority of the judicial branch be? Should the court, shall we say the Supreme Court of a country, be empowered, be authorized to disqualify legislation passed by the legislature? Should it be able to rule certain actions of the executive branch to be unlawful? And if so, on what basis? We also have another problem, and that is some countries, such as the United States, for example, have a constitution. And therefore it is understood by Americans, who, at least in theory, all agree that the Constitution is the basis for their society, for the way their society should be run. There therefore is logic in the claim that the Supreme Court should be able to declare an action taken by a branch of the government or a law passed by the Congress to be unconstitutional. That is to say, that it does not square with certain stipulations and basic assumptions of the Constitution. Of course, as with any legal discussion, this involves interpretation and various forms of discussion as to the meaning of any particular statement or wording in the Constitution, but at least there is a basis, a written document that is accepted by all, that constitutes the basis of that republic. And there are, on the other hand, countries, such as Israel, for example, which does not have a constitution. And therefore the question becomes very critical. On what basis exactly does a court rule an action of the government or a law passed by the legislature to be unlawful? It can't claim that it's unconstitutional because there is no constitution. And it would seem reasonable to respond that a court can make such a ruling only when the action in question or the law that was passed by the legislature somehow contravenes or disagrees with a legal, binding legal statement or practice as appears in the laws of that land. For example, in the United Kingdom, where there is no constitution, the High Court does not have the authority to rule that legislation passed by Parliament is unlawful. It does not have that power. The High Court may recommend that Parliament re-examine the issue, that certain issues were raised regarding this piece of legislation. An appeal was brought before the court, and certain question marks exist, and perhaps this needs to be reconsidered. But if, upon reconsideration, Parliament states that this is what we consider this is what the law should state, and we consider this to be correct and proper, and yes, we have looked at it once again, and we have not changed our minds, that remains the law of the land. And the basis for that approach to this question is essentially the concept of democracy. The very concept of democracy is generally understood to mean that it is the people, by way of their elected representatives, who decide what the laws of the country should be. Because if there is no constitution and there is no generally accepted religious imperative, for example, if the Bible was accepted by a majority of people, or it was stated in a constitution that the Bible, for example, is the basis for deciding all manner of ideological and moral issues, then yes, that is one way of going about these things. And in a Torah state, that of course would be the case. The Torah would be the final authority. The Torah, in fact, is the constitution of the Jewish people. But in a country which is based on the notion of separation of what's called church and state, religion and state, therefore religious predilections and opinions are not supposed to be the final arbiter, then on what basis are such decisions to be made? If not by the democratic principle that the majority's opinion will be accepted. If, on the other hand, the judicial branch arrogates to itself the authority to dictate moral standards and all manner of issues which pertain to personal beliefs and the opinions and value systems of different people, if the court arrogates to itself the authority and the right, the prerogative, to adjudicate such matters, one has to ask on what basis is it doing so? But why should the opinion of a judge, his personal view, his personal inclination, or his philosophy of life, why should that be more important and more worthy of consideration than the view of the average citizen? And I would like to quote a few lines from a book that I have here entitled Elements of Democratic Government. As far as I can tell, this is a textbook for political science studies at the university level, published by Oxford University Press in 1958, authored by J.A. Corey, Professor of Political Science at Queen's University, and Henry J. Abraham, Associate Professor of Political Science at the University of Pennsylvania. Page 28. The following is discussed. It states here that respect for individual personality is the highest value and the essential yardstick by which a democratic society should run its affairs. And they go on to explain as follows. If the claims of individual personality are to be considered the superior value and the highest of the democratic ideals, then it should be asked, why should this be the ultimate? Should not our highest aim be to do the will of God or to serve truth and goodness? The ideals of democratic government, that is, government controlled by the people for their purposes, must be widely accepted and believed by the people, or those ideals cannot by definition be democratic. Respect for individual personality is the maximum on which it has been possible to get widespread agreement. If we say our highest ideal is to do the will of God, that raises the question of what God's will is. If we say our highest ideal is to serve truth and make it prevail, that raises the question of what truth is. Answers to these questions will turn on religious and philosophical views about the nature of the universe and man's place in it. And here we meet divergent answers and hot dispute. And therefore we are beyond the area in which general agreement is possible in our present state of knowledge. Here I must reiterate, and we must all note, that the authentic Jewish concept of a state, which is a state based on the values and the concepts, precepts of the Torah, and that the Torah is in effect, the constitution of the Jewish people. In such a state, the questions that we just read would not be asked, would have no place, because there, in that kind of state, the question, what is God's will, could not be asked. God's will, as we know it, is what we find in the Torah. It is, of course, true that, as with any philosophical or legal system, issues frequently must be discussed and analyzed by experts in that particular system of law or philosophy in order to render a decision as to what should be done, what is correct and proper according to that system. And therefore one needs a court, a Sanhedrin, a Beit Din Gadol. But in a country where you do not have a constitution and there is no agreement that the state is based on the Torah, for example, or any other religious text or foundational document, then we have to ask ourselves, by what right can judges dictate to others what their moral standards, what their behavior should be, what is considered proper, what is considered immoral, etc.? These are very real questions. In Israel, we find ourselves in a very unfortunate and unusual situation. Unusual because there are almost no countries on earth in which the situation is as we find in Israel today. We find a Supreme Court functioning in a country which has no constitution, functioning in a country which does not claim to be based on a clear set of moral principles and standards, such as the Torah, and yet they claim to have the right, because they consider themselves to be enlightened and wise, and these are not my words, these are the words of former President of the Israeli Supreme Court, Aaron Barak, who spoke of the obligation of the court to take into account the opinions of the enlightened parts of society, which of course is just a code, another way of saying those sectors of society that agree with my position. That is a very unusual and definitely undemocratic way of dealing with this question of the separation of powers and the various jurisdictions and authorities of the various branches of government. It should also be added that in most democratic countries, judges of all courts, and certainly of the Supreme Court, the highest court of the land, must be are chosen by and must be confirmed by the elected representatives of the people. And because it is certainly true, as we just read a moment ago, that many issues in human affairs come down to philosophical and religious inclinations and views and understandings of the world, there is a certain logic in the fact that, for instance, in the United States, the president, who is elected by the people, should nominate judges for the Supreme Court, and that candidate for the Supreme Court must be confirmed by the elected representatives of the people, elected democratically by the citizens. Because if the judge is going to have the power to decide all manner of issues pertaining to human affairs, then he must receive a mandate from someone. The Israeli Supreme Court, on the other hand, and the nomination of judges to that court, and all courts for that matter, in Israel today, is not an open and transparent process. It is all done behind closed doors by a very small committee which essentially does not represent in any meaningful way the elected representatives, does not include and does not take into account the elected representatives of the people, and essentially it is the judges themselves who have been successful in Israel in forming a kind of clique in which they nominate themselves and their cronies. And this is clearly undemocratic. It goes without saying that this is not the way that the Torah would prescribe the nomination of judges, and it certainly is not in keeping with democratic principles. This is why so many people today in Israel and abroad have become aware that the Israeli system of government is in crisis mode, that the executive branch and the parliament have very little power because they are frequently stymied by and dictated to by the judicial branch. This is a state of affairs that must be addressed.
The production of these videos and maintaining this channel demands much time and money. If you enjoyed this video, please show your appreciation and support. To make a donation, please go to www.machonshilo.org and press the PayPal button which appears on the upper right-hand side of the home page. To sponsor a video or purchase Birkon Nusach Eretz Yisrael, please write us at office@machonshilo.org.